Hi, I'm Lesley Arizmendi with Equip for Equality. If you are living in a long-term care facility, you have the right to continue living there. A facility can make you leave only for a few reasons. This video will inform you of the reasons nursing homes and other long-term care facilities may discharge or transfer you against your wishes, your rights in connection with the discharge or transfer, and how to ask for a review of the facility's decision. You are being involuntarily transferred if your current facility is moving you to another facility, but you do not want to move. You are being involuntarily discharged if your current facility fully releases you from the facility against your wishes. Your rights and the requirements for long-term care facilities are the same for both a transfer and a discharge. You are not being involuntarily transferred or discharged if the facility decides to move you to a different bed in the same facility. A long-term care facility can discharge or transfer you against your wishes for only one of 6 reasons. The facility cannot meet your medical needs and the move is necessary for your welfare. Your health has improved so that you no longer require the facility's services. Your physical health or safety is at risk. Safety of others, including other residents, facility staff, or facility visitors, is at risk. You have not paid or are late paying the facility's bill, and the facility has given you written notice and 30 days to pay. The facility closes or stops operating. When a facility is making you leave, you have rights. You have a right to receive written notice of the transfer or discharge. The facility must give you or your representative written notice at least 21 days before the date it plans to discharge or transfer you. If the facility does not give you written notice, you should request it. If you move from the facility and do not request a notice and appeal the discharge or transfer, you may be agreeing to a voluntary discharge or transfer. The facility does not have to provide you with at least 21-day notice if your doctor orders an emergency transfer or discharge because of your health care needs, or if the facility is moving you for the physical safety of others at the facility. If the facility is moving you for the safety of others, the Illinois Department of Public Health should immediately offer you transfer or discharge and relocation assistance. You have a right to discuss the planned involuntary transfer or discharge with the facility director or the director's representative. You have a right to return to the facility after being hospitalized unless the facility gives you a written notice of involuntary transfer or discharge. If you receive Medicaid and are hospitalized for 10 days or less, the facility must allow you to return when you are released from the hospital, even if the facility has given you a written notice of involuntary transfer or discharge, except under an emergency discharge or transfer. If you receive Medicaid and are hospitalized for more than 10 days, the facility must let you return if there is a bed available and you still require the care provided by the facility, except under an emergency discharge or transfer. If the facility is full and you still require that level of care, the facility must allow you to have the first available semi-private room. You have the right to make payment and stay in the facility. If you are a Medicaid recipient and the Department of Healthcare and Family Services, also known as HFS, has taken action against you that will negatively impact your benefits, the facility may not transfer or discharge you for that reason if you have appealed HFS decision. The facility can provide you with your 21-day notice of discharge or transfer only after HFS or the court has made a final decision on your appeal and you have received notice of that decision. You have the right to appeal the transfer or discharge. You should complete and mail in the form that the facility gives you with the notice of discharge and transfer in order to appeal. You must do so within 10 days of receiving the written notice. The Illinois Department of Public Health should hold a hearing at the facility within 10 days from when you filed the appeal. You have the right to stay until your appeal is decided. If the Department of Public Health decides you should be discharged, you should not have to leave right away. The facility should not make you leave before the 34th day after you receive the notice of discharge or the 10th day after the Illinois Department of Public Health's decision, whichever is later. The facility can make you leave earlier only if there is an emergency situation with your health care needs or your move is necessary for the safety of others. If you disagree with the Department of Public Health's decision, you may file a petition for judicial review with the court within 15 days of receiving the department's decision. If you file a petition, you will not automatically be allowed to stay at the facility until the court rules. You have the right to a safe discharge or transfer. Before a facility can discharge or transfer you, the facility and the Department of Public Health must prepare you to be sure that the discharge or transfer is safe and that the new setting is appropriate for you. The Department of Public Health must offer you relocation assistance, including information on available alternative placements. You have the right to be involved in planning your transfer or discharge, to visit other facilities, and to choose among available alternatives, except in emergencies. The facility you are being discharged from must offer you counseling services before the transfer or discharge. For more information, contact the agencies listed below or see Equip for Equality's fact sheet on this topic. You can also contact Equip for Equality at equipforequality.org.